So let's be punctual and start right at 1 o'clock. So good afternoon and welcome to the first of AgSafe Alberta's 3-part speaker series that will provide you with great information and tools to develop your safety culture as we head into another growing season. For anyone not familiar with AgSafe Alberta, we are the Health and Safety Association for farmers and ranchers in our province. My name is Kaya Fosham, and I am the Safety Manager for AgSafe Alberta. It is my privilege to introduce you to our speaker, Christopher Spasoff. Christopher is one of only a handful of lawyers with experience on both sides of the occupational health and safety regulatory system, both as an OH&S prosecutor and as an OH&S defense lawyer. But just as importantly, he is a small-town farm boy from Saskatchewan. Christopher is often sought out for his practical, easy to understand advice and common sense approach to problem solving. He left the Crown in 2014 to establish F2 Legal Counsel, which is the first and only law firm in Western Canada that is exclusively dedicated to the practice of occupational health and safety law. He is an advisor to both employers and to workers on a variety of OH&S issues and has worked with producers like you. He is passionate about sharing his extensive knowledge and experience wherever possible and is a very entertaining speaker. If you are not already familiar with Christopher or F2 Legal Counsel's, forgive me if you do not already have F2 Legal Counsel's contact number in your phone, you will after this. So for approximately the first hour, Christopher will present information on how OH&S legislation relates to your operation. He has kindly agreed to spend the second hour answering questions. You are welcome to enter questions into the chat box as you think of them, or write them down and save them until the end, and we can address them then when it's a little more open. As well, we will be recording and posting this webinar in the AgSafe Alberta portal, so you can go back and listen to it again or refer your friends and neighbors to it. Today's session is called OH&S Law, JD Edition, a clever title I am sure you will appreciate. And with that, I will turn you over to Christopher. Go ahead.
Thank you very much, Kai. I appreciate that. Appreciate the introduction, appreciate the opportunity to come and chat with you all today. And I want to get the elephant out of the room right off the bat. For those of you thinking that, oh my goodness, 2 hours listening to a lawyer drone on, listen, the most important part of that introduction was the small town farm boy part. So I hope you paid attention to that part. And I'm going to be honest with you. The OHS Law JD edition, for those that aren't familiar with the JD part, to me, JD means one thing, and it means something green, which you see right there on your screen. JD technically also means Juris Doctorate, which a few years ago, lawyers had the ability to switch over their Bachelor of Laws, which is the degree that we get, to a Juris Doctorate, and in theory, we could call ourselves doctors. Now, I'm not that pretentious. I'm going to be upfront. I never in a million years dreamed I would ever see anything or associate myself with the JD. But this opportunity was just way too great to pass up, because for the first time ever, and probably the only time in my career, I get to use this little spin on JD, because as I say, the most important part is where I come from, and that's a farm where everything was green. So that's kind of the reference to the JD side of things. Again, I appreciate setting the stage, Kai, with respect to my experience. I've seen it on both sides of the equations, my friends. And so that's what I want to share with you today. Some of that practical experience. I want to cut through some of the rhetoric that you've no doubt heard over the course of the past several years, and really to get at the heart of some of the issues that you're facing and some of the questions that you find yourselves asking on a day-to-day basis. So let's be upfront. OHS has been in the news a lot the last few years. Okay, and you're probably wondering, like, where's the slides? Are there going to be slides or anything along those lines? There's no slides. Okay, there is no slides, and you know why there's no slides? Because I am a firm believer that you accomplish a lot more through a conversation or through a discussion of sorts than you ever do through a PowerPoint. Okay, PowerPoint has its time, has its place, but I'm a very firm believer that those people that use PowerPoint use it as a crutch, and it's essentially kind of because you don't know what you're talking about a whole lot. That's my own personal take. So you're going to be stuck looking at me, or you're going to be stuck looking at that intro slide, but hey, that's an okay slide to look at, right? Kind of a little reminder that spring is right around the corner. So OHS has been in the news a lot the last few years, right? And I'd go so far as to say more than ever before. And that's because there have been some big changes, both here in Alberta and really throughout the entire country. And it all started with Bill 6 back in 2015. Yes, we'll still talk about quote unquote Bill 6 because that very word or that phrase resonates with a lot of you, I suspect. But it was Bill 6 back in 2015 that really changed how OHS legislation applies to farms and ranches. And then in 2018, we had Bill 30, through which a whole new OHS Act was introduced. And now, just a few weeks ago, we have the government passing Bill 47, which in large part, at least outside of the workers' compensation stuff, is set to take effect in September 1st of next year. So a lot of attention right now being given to occupational health and safety. So why all of these changes? Well, the simple answer is that legislation is constantly changing. And when you're trying to enact laws that are designed to get you from point A to point B, or from the start of a shift to the end of a shift safely, because that's really what the OHS laws are designed to do, the simple reality is that you're never going to get it completely right the first time. Okay, it's simply not possible. It's not going to happen. Think of the OHS legislation as a roadmap of sorts. Okay, but just like any roadmap, it's static. It doesn't change with the conditions, right? Or if there's construction or any other set of circumstances that might arise. So it's necessary to change that map from time to time, to add to it, or perhaps change the route if another safer one is discovered or a more efficient one is presenting itself. That's the simple answer for why we see all of these changes. But when it comes to farming and ranching and the changes that we've seen in the past few years, I'll be completely honest with you. It's really been anything but simple. And unfortunately, that's in large part due to the politics that were involved, and to a certain extent to the politics that continue to be involved. Now, a lot of people will no doubt want to point a finger and say that everything was fine before the politicians got involved, but I'm going to level with you. Things weren't fine. They were far from it, in fact. But in order to understand why that was the case, you really have to get behind all of the political rhetoric and the reasons that you heard in the media as to why changes to the legislation needed to be made, because there were really compelling reasons. But these notions of, well, farms are just inherently unsafe, or we got to protect our kids, and all of the other things that you heard, while they made for great sound bites, they really weren't getting at the core of the issue. In order to understand why the legislation needed to change, you really need to step back in time a bit to understand why farming and ranching was exempt from the legislation in the first place. And you need to understand that that exemption was never intended to operate as a carte blanche or be all and end all or overarching exemption for any and all farming and ranching operations. Okay, it was never intended to operate that way. If you actually look at earlier versions of the OHS legislation, and specifically at the farming and ranching regulation, you'll see that while certain farming and ranching operations were specifically excluded, and there was a list of them, and you know what, I'll share that list with you with respect to the new legislation. There's a list of them as I now go to share my screen and try to find a window amongst my many windows that were open. There we go. So as you can see here, from this particular exemption, this is how it exists right now. Okay, now this has been updated, but this is kind of what it looked like back in the past, pre-2015. There was this exemption that said excluded farming and ranching operations. These are what they are, okay? These are the operations that are excluded: the production of crops, including fruits and vegetables through the cultivation of land, the raising and maintenance of animals or birds, the keeping of bees. And then for greater certainty, they said these things aren't farming and ranching operations. These things aren't excluded. And that was the processing of food or other products from the operations referred to, the operations of greenhouses, mushroom farms, nurseries, or sod farms, landscaping, and the raising or boarding of pets. Okay, so right from the very beginning, there was always this notion that although there was going to be an exemption that applied to farming and ranching, it was never going to apply full bore to absolutely everything and anything. And now I'm kicking myself because I shared this screen and I can't get back to the actual presentation. What have I done? Oh my goodness. Why did my little screen go away? There we are. It's up there at the top. How goofy. I apologize for that, my friends. There we go. We're back just like that. So you can see there what the exemption looks like now. Well, back in the day, it was a little bit different. It still had the production of crops, including fruits and vegetables, the cultivation of land, raising and maintenance of animals or birds, the keeping of bees. it still had all of those things, but it had a little bit of introductory language to it. And it said, here's the things that are excluded. Operations directly or indirectly involved in any one of those things. Okay. Now, again, we just went through it and we said cultivation of land or production of crops through the cultivation of land, raising and maintenance of animals or birds, and keeping of bees. Exemption applied to those things. Similarly, there was that second part that said, okay, well, if it's an operation involved in the processing of food or other products or greenhouses, mushroom farms, landscaping, raising and boarding of pets, then the exemption doesn't apply to it. Now, yes, it's strange that you could raise an entire herd of cattle without having to worry about complying with the OHS legislation, but not if you raised a family of cute little morkies. But I digress. Okay, the important part of the distinction is recognizing and understanding that the farming and ranching exemption, right from the beginning of time, seemingly, was always intended and set up to be limited in its scope. Okay, in very simple terms, it was there to protect the quote unquote family farm. And of course, anyone that's involved in farming operations or ranching operations knows that trying to define such an endeavor, trying to define what all is involved in a farming and ranching exemption is an incredibly difficult task. Okay, what's all included in the small family farming operation? Well, that's tough, but the legislature sought to do exactly that. The problem is when they put together the exemption trying to do that, the language that they ended up using didn't work, or perhaps it worked too well. Either way, the exemption ended up going far beyond what was intended and protecting more than just the family farm. Now, what I mean by that is best illustrated through an example, through an actual case that took place well over a decade ago, okay? And the case involves an organization or company here in Alberta called Northern Forage. Some of you might be familiar with Northern Forage. But Northern Forage is a company based in Nampa that produces Timothy hay, largely for export overseas. And as part of its operation, it uses 40 acres of land, equipment for cutting, raking, baling, stacking, loading, hauling. It had a 192,000 square foot building for storage, a 45,000 square foot building known as the compression facility that was equipped to store, destack, double compress, restack, and load this Timothy hay for shipping. Had a building that it used as an office, a shop, a drying facility. My point here is it's not something that we would typically think of perhaps as a small operation. And it's certainly not what a lot of us would perhaps initially think of when we picture a quote unquote family farm. Now, nevertheless, facing charges under the OHS Act for a fatality that happened at its compression facility, Northern Forage sought to rely on that farming and ranching exemption as a complete defense, saying, listen, you can't charge us because the OHS legislation doesn't apply to us. We're a farming and ranching operation. That exemption covers us. Now, keep in mind, I said that exemption was only ever supposed to apply in a limited sense. It was only ever supposed to apply to small family farms. But when Northern Forage argued this case in court, the court came back and said, you know, when we note the incredibly broad meaning that can be attributed to a phrase like directly or indirectly involved in the production of crops through the cultivation of land, the court said we have no choice but to rule in favor of Northern Forage. And the Court of Appeal, or sort of the Court of a Queen's Bench on appeal, held the exact same thing. They said the exact same thing. They actually went one step further, noting that what took place at Northern Forage's compression facility was really no different than what took place in farming operations of the past, where the grain crop was cut by way of a binder, bound into sheaves, and then transported to the threshing machine, where the grain was separated from the straw and chaff. They said, well, notwithstanding that the exemption was only supposed to apply to these small family farming operations, when you read how it is written in that directly and indirectly language and how it is set up in the legislation, it applies to a whole lot more than just a small family farm. So the Crown in that case tried to argue, well, the act of compressing the hay crop into a bale at the compression facility, that's akin to the processing of food or other products. And so the exemption shouldn't apply, because remember, there's that second part that says if it's processing of food or other products, then the exemption has no applicability. And the court heard that argument. They said, no, that's not accurate. We want nothing to do with that. And so with that, the charges against Northern Forage were stayed. They were pulled. They were dropped. Northern Forage was successful. And the door was really opened. Okay. Now, the Crown didn't pursue a further appeal. And regardless of whether or not you agree with that decision or not, one thing was very, very clear. No longer was the farming and ranching exemption from OHS law operating just to protect the quote unquote family farm here in Alberta. Now it was operating and available to protect large, sophisticated, and in some cases completely independent corporate entities that employed any number of workers from outside of that family unit. And if you thought that defining the quote unquote family farm was difficult, you only need to imagine the sheer number of organizations indirectly involved in that endeavor or aspects of that endeavor that would now start falling through the cracks. So I can tell you through experience, because I argued that precedent, I argued that case, if you will, on several occasions following that decision to say, well, this company, even though this company perhaps warehouses seed, fertilizer, chemical, et cetera, they have an incident or a fatality at their workplace, farming and ranching exemption applies. Why does it apply? Well, because the storage of seed and fertilizer and chemical, even though it's not by a small family farm, which is what that exemption was originally designed to capture, still directly or indirectly involved in the production of crops, right? You need to fertilize, you need to have pesticides, herbicides, et cetera. Okay. And so successful on that argument. At the Crown's office, while I was there for a period of time, cases would come through where you had third-party trucking companies, for example, picking up product to take from one location to another. Okay, not agricultural trucking companies per se, but just independent third-party trucking companies. They have an incident. If that incident took place while they were hauling product from point A to point B, according to that decision in Northern Forage, that would be sufficient to engage the exemption. Okay, and so you had all of these different types of scenarios and all of these different types of companies and groups that were benefiting from this exemption, even though they might only have tangentially been involved in farming and ranching. They could still rely on the farming and ranching exemption regulation. Okay, now that was the situation heading into 2015. I'd actually spoken at a health and safety event back in 2013-ish, 2014-ish, and said, listen, top 3 things to be on the horizon and on the lookout for in the coming years are changes to these three areas. And my third area was farming and ranching. It was on the radar. Okay, it was on the radar before 2015. It was on the radar before the NDP took power here in the province. It was just a work in progress. Now, granted, once that new government took power and Bill 6 was introduced, there was a lot of quote unquote miscommunication or just flat out misinformation, for what it's worth, that was tabled when that bill was first introduced. Okay, there was a lot. But despite all the rhetoric and follow-up statements from the province at the time that the changes were never quote unquote intended to remove the exemption for the family farm, the fact is that the original version of the bill did just that. Okay, it may not have been intended that way, but make no mistake that in effect, the OHS legislation would have applied full bore to the family farm, just like any other employer or industry. In very simple terms, the first draft of Bill 6 simply removed the farming and ranching exemption in its entirety. And by removing the exemption, it removed the one and only thing that was preventing the OHS legislation from applying to farmers and ranchers. That's the end of the discussion. Now, yes, there were amendments, but I mean, that in and of itself was a bit of a disaster. And you can't help but wonder just how much better the bill would have been received had some context for the changes and more specifically, the need for the changes, why they were required, had been provided. I mean, while modern day farming and ranching operations certainly aren't always these small scale operations that they used to be, I mean, I consider myself and my kin, so to speak, reasonable people, right? Farmers and ranchers are reasonable, hardworking, salt of the earth people. And provided with the right information, I'd like to think that all of us would have taken issue with a third-party trucking company with no real ties to the ag industry, hired only to transport product from one location to another, relying on the exemption. And I genuinely believe that when explained and tabled properly, everyone might acknowledge that some form of change was necessary. But alas, it didn't come to be that way. And in any event, while it was a key point of contention at the time that the bill was introduced, the confusion around that particular issue, at least, and whether or not the family farm was going to be exempt or not, was tempered through amendments that were made to the bill. Okay. And when the bill ultimately passed, a clear exemption for the family farm was added. although the extent to which it applies is really dependent on the nature of the family relationship and the payment of wages, okay? In very simple terms, if a farming and ranching operation paid wages or pays wages to anyone other than a specified family member, it fell and continues to fall within the reach of Bill 6 and needed to / needs to comply with the Act. And although at that time, not immediately, because they'd set up some focus groups to flesh out what compliance would look like, it was anticipated that you would also have to comply with the regulation in the code, okay? That's where things were left as a result of Bill 6. If the exemption didn't apply to you, which was still kind of the same, they removed the directly or indirectly language and tweaked that a little bit, but then they also introduced this notion that it only applied to the family farm in circumstances where you weren't paid wages. Okay, and so family was defined, the familiar relationships that were caught by the exemption were defined. Wages is defined as something taken from the Employment Standards Code, and you had to meet those requirements. If the exemption didn't apply and you didn't meet those requirements, then the Act, regulation, and code would all apply to you. Now, it's important that you understand that context and that background, because fast forward a few years to January of 2020, okay? We now have the new government come in, the UCP government come in, and they came in on a platform that says we're going to repeal Bill 6, and they say we're going to repeal Bill 6. And a lot of farmers and ranchers say, that's great, you're repealing Bill 6, fantastic, that's what we want. And in many ways, they say that Bill 6 has been repealed. If you look at the Government of Alberta website right now, you'll actually see a page that specifically states, promise made, promise kept, repeal Bill 6. But here's the thing. It wasn't a clean break. It wasn't a full repeal. And that's caused a lot of confusion for a lot of different people. And that's what I want to try to clear up here this afternoon. It couldn't be a full break because at least a part of the Bill 6 changes were addressing a problem with the OHS legislation that had been in existence for over a decade, while still preserving some semblance of the family farm. I mean, even on the promise made, promise kept webpage, the government acknowledges that the Farm Freedom and Safety Act, which basically took the place of Bill 6 in changing the OHS legislation, still requires compliance with the quote unquote basic safety standards, quote unquote basic safety standards that are set out in the OHS legislation. That term, basic safety standards, that phrase, combined with this understanding or thought process that Bill 6 has been repealed, has led to a host of problems. Because the reality is that farmers and ranchers are still subject to the OH&S Act. And the suggestion that there's something basic about complying with that act is really, really far from the truth. And I can't stress that enough. What a lot of folks don't realize is that the OHS Act is really the piece of the puzzle in terms of the legislative scheme that has all the teeth, okay? It's what gives OHS officers their powers, their ability to enter onto farms and ranches, to issue stop work orders, penalties, and to pursue charges against farmers and ranchers that aren't compliant. For what it's worth, every single time an OHS prosecution has taken place in this province, every single time charges have been laid under that legislation, with the exception of once, and I genuinely believe that exception is because it was a new prosecutor that just kind of missed it, but there's been a charge for failing to comply with those quote unquote basic safety standards. Every single time you see charges, one of them is a failure to comply with basic safety standards. Sometimes it's the only charge, okay? And that's in the Act, and the Act is still in full force and effect, okay? For those of you that aren't captured by the exemption. All right. Now, a part of what the repeal of Bill 6 did is it said, okay, well, the code and the regulation aren't going to apply anymore. It's just the Act. And I want to talk about that a little bit too, but I want to spend a little bit of time going through the Act with you. Okay. I want to go through a little bit of a crash course, if you will, in OHS law and the interpretation of legislation more generally. And to do that, I'm actually going to pull up or share a copy of the OHS Act here. I've learned from my mistake last time, so I'm not going to get lost in this. But there you go, okay? There's the OHS Act here. You see it right here. This is available online at this website. I can drop that into the chat box for you later. But there you see it, okay? That's the OHS legislation. And in very simple terms, An act, as it's called, the OHS Act, is a written law that says, listen, this is what we want to do. That's the intent. And this is how we're going to do it. And when it comes to the intent of the legislation here in the Occupational Health and Safety Act, it's actually specifically spelled out for you in Section 2. It says the purposes of this act are the promotion and maintenance of the highest degree of physical, psychological, and social well-being of workers, to prevent worksite incidents, injuries, illnesses, and diseases, protection of workers from factors and conditions adverse to their health and safety, and to ensure that all workers understand their rights and have the ability to work without discrimination. Okay, that's the goals of the legislation. Now, in terms of how the legislation is going to try to accomplish those goals, the Act goes on to identify a number of key players, be they employers, workers, supervisors, owners, and a few others. Okay, and you can see there's employers, there's supervisors, there's workers, suppliers, service providers, owners, contractors, prime contractors. You see all of these different players involved here. Okay, and after it identifies all of those different players, what it does is it sets out, just like the heading says, obligations on those different players. So for employers, you've got all of these obligations that you have to follow. For supervisors, you've got all of these obligations that you have to follow. Okay. So essentially what happens is the Act sets out these number of key players. It then spits out these specific obligations or these general duties, or as you've come to know of them as these basic safety principles or these basic safety rules. Okay. These basic safety standards. And then what it does is it says, we're going to give this other group down here, if we keep on scrolling through, we're going to give this other group down here, OHS, certain authority to do certain things. Okay, we're going to give OHS the authority to come out and to do inspections and investigations and ensure compliance. And where there's no compliance, we're going to give them the teeth that they need and the tools that they need to enforce. Okay, so we're going to give OHS certain powers to make sure that you comply. And by gosh, if you don't comply, you can be subject to fines and penalties that are enforceable in a court of law. Okay, so you get your orders, your different types of penalties. There you go. You've got administrative penalties and you've got prosecutions. Okay, right down here in Part 10, your offenses. That's how the legislation is set up in very simple terms. That's how it works. But in order to truly understand how it works, you have to look at it in a little bit more detail to see exactly what each line and in fact, what each word in the legislation means. And I'll be honest with you, that's because lawyers like to make things more complicated to some degree. And when I say that, what I'm really getting at is that in law, the words that appear on the paper don't always have the same meaning that we would give them in our regular everyday usage. Okay. Now, case in point, we're not going to go through the entire act. There's a lot of sections in there, and that would make for a really dry session today. But I do want to highlight a few points for you just in terms of how the legislation or the act in particular works generally because of this whole notion of basic safety standards. Okay. This act is long. All right. It's over 80 some sections long. Okay. And you've got, here you go, 102 sections long. That's a lot. To talk about that just being basic safety standards is a real simplification of what's going on there. So what I want to do is I want to walk through a few areas to demonstrate for you, again, just in general terms, how it works. And as I say, the words on paper don't always mean the same thing that we would think that they mean in our regular everyday usage. And case in point, I want to draw you to the term contractor in the legislation. Okay, when I say that term, many of you no doubt start thinking about the repair company maybe that you brought in to fix your furnace before winter hit, or something along those lines. Many of you likely wouldn't consider yourselves a contractor, or your farming and ranching operation a contractor, because typically when we hear that word, what we think of is a third-party company. But under the OHS laws, as we scroll up here, under the OHS laws, a contractor is something very different. That term means something very different. Okay. And how do we determine that? Well, we need to look at the legislation. Specifically, we need to look at the definition section to see what contractor means. And when we do that, when we pull up the term contractor, we see that it means something very different than what we would ordinarily consider it to mean. It means a person, partnership, or group of persons who, through a contract, an agreement, or ownership, directs the activities of one or more employers or self-employed persons involved in work at a work site. So could you possibly be a contractor? Notwithstanding that in your day-to-day discussions, you may not think that you fit within that definition. Based on the definition that's in the legislation, contractor means a person. You're certainly a person. If you have a company is a legal person, okay? So do you ever, through a contract, an agreement, or ownership, direct the activity of one or more employers? An employer, if you look at the definition, just means essentially someone who engages one or more workers. So if you hire a company to come in and do some work, guess what? You're a contractor, okay? You fit within that definition. Even though you maybe don't consider yourself a contractor, you fit within it, all right? When they talk about directing the activities, that's been interpreted in various cases to mean simply directing what work be done, not how to do the work per se, but in very simple terms, just essentially asking or requesting that certain work be done. That's sufficient to hit that directing aspect of things, okay? So you see that in order to determine what contractor means, you have to look at the legislation. And so let's look at it, or come at it, from 30,000 feet and see which of all of these roles might apply to you, okay, under the legislation. And again, we're not going to go through it in great detail. I'm going to help you out a little bit here because obviously enough, I'm pretty familiar with it, having worked with it for, well, in fairness, this legislation has only been enforced since 2018. But having worked with OHS legislation generally for the past 15 years, I can save you a little bit of time there. So coming at it from 30,000 feet, as a farmer or rancher, which of these different parties that I identified earlier might you fit within? Well, I'm going to tell you right now, at a minimum, you're going to fit within employer, okay? Employer is, whoops, as we go back to the definition, a person who employs or engages one or more workers. What's a worker? Well, you see down here when you scroll down to worker is a person engaged in an occupation, including someone who performs or supplies services for no compensation, but does not include, okay, a student, or except for the purpose of section 5A and B, which we won't talk about today, but the following persons engaged in a farming and ranching operation specified in the regs, right? So those, how farming and ranching operation was defined in that other document. If you're one of those and no wages are paid to you, or wages are paid to you and you're a part of the family unit, if you look back up and chase through this definition here, okay? So, and then where are we? Up here. If you chase that back through, you'll see that, yeah, you know what? You're an employer, okay? If you bring people on and you have people performing work for you, and those people are paid and they're outside of the family unit, you're an employer. What else might you be? Well, you're an employer, you're an owner, okay? I'll tell you that right now. The odds are pretty good that you're an owner. If you're the person registered on land title at the land titles office, okay? If you're the person registered on title, even if it's your company, that means you're also the owner. So right off the bat, we know you're an employer and you're an owner, okay? What else might you be? Well, there's another term in the legislation called a supervisor. Supervisor means a person who has charge of a worksite or authority over a worker. Do you have charge or control of your own worksite? I suspect you do. Do you have authority over a worker? I suspect you do. The way that the courts have interpreted that term supervisor and authority over worker is in very, very broad terms. Essentially, if you have the ability to influence a worker's day, the activities that they engage in that day, if you have the ability to influence the decisions that they make, where they are, et cetera, you are a supervisor, okay? So if you have someone working for you, you're their supervisor. So now you've got employer, owner, supervisor. Those three all apply to you. You fit within each one of those. What else maybe? Well, worker, person engaged in an occupation. Do you actually go out there and help out? Are you hands-on in the course of your business, in the course of your farming and ranching operation? If you are, odds are pretty good you're going to fit within the worker definition too, okay? Because even if you're not necessarily hands-on, you're still doing something. Even if you have a company and it's the company that runs the business, the company still needs a living, breathing human being to direct it and to give it instructions. And by doing that, you are a worker, okay? So guaranteed you're going to be a worker as well. So now we've got employer, owner, supervisor, worker, okay? We said maybe contractor. You might fit within that definition. Well, why does all of that matter? Why does it matter if you're an employer, an owner, a supervisor, a worker, maybe a contractor, maybe others? Why does that matter? Well, it matters because once we've identified the various roles or positions that you occupy under the legislation, under the act, you then need to look at these corresponding obligations. And I already highlighted some of these very quickly, but all of these corresponding obligations are set out in sections 3 through 12 or 13 of the Act. And they're long lists, right? The obligations on employers, all of these, the obligations on supervisors, all of these, obligations on workers, these, okay? And it keeps on going, obligation on owners, all of these, right? These are known, these general obligations, these general duty clauses, these are the quote unquote basic safety standards that, again, the term basic is really a misnomer. I can tell you every single time charges are laid, you're finding one of these clauses listed as having been breached. And that's because they're really a catch-all of sorts, if you will. Okay, they're a catch-all of sorts for the over 800 or more specific sections that can be found in the OHS code. Now you say, oh, well, but the code doesn't apply. Doesn't matter, okay? These general duty sections, and I'll talk a little bit more about that in a second, but these general duty sections all say much the same thing, but in a slightly different way, okay? And to demonstrate that point, what I want to do is I want to focus on the general duty that's on employers, okay? Or at least a part of the general duty that's on employers, which, as you can see, is to take all reasonable steps, or as far as it is reasonably practical to do so, to ensure the health and safety and welfare of workers engaged in the work of that employer, or workers not engaged in the work of that employer but present at the worksite. You also have a duty to make sure that people in the vicinity of your worksite who could be affected by it aren't, okay? That they're not impacted by hazards originating from the worksite. Well, what does that mean? Hey, we had our farm 5 miles out of town. We had to transport our equipment from home out to the farm because we stored it at our yard, right? If we were to have a car accident or we were be on the road with that equipment, guess what? We owe a duty not just under Traffic Safety Act and other pieces of legislation along those lines, but now under the OHS legislation, we have an obligation to those other users of the road. And I can tell you right now that OHS, with respect to traffic incidents and that sort of thing, they used to be relatively hands-off. They're not hands-off anymore, because in every single incident where there is a traffic issue that arises, they have to come in and perform this assessment to see whether or not there was a hazard emanating from the worksite, because worksite isn't defined incredibly broadly in the legislation. Worksite essentially can mean a chair, a vehicle, an office, a building, 40 acres, 80 acres. I mean, it's incredibly broad, right? It's just anywhere that work is being performed or would likely be performed, okay? So I want to focus though on this general duty, okay? Which is to take all reasonable steps to ensure the health and safety of workers. That's how it's written there for employers. And then I want to look at it down here with supervisors, which you can see is to take, all necessary precautions to protect the health and safety of every worker under your supervision. So you've got these two different duties, okay? Reasonable steps versus necessary precautions. And you can see the slight variation of wording there, but the real issue here is doing everything that can be done, whether they're reasonable steps or necessary precautions to protect the health and safety of workers, all right? So how do you know what all reasonable steps and what necessary precautions are? Because that's very, very general language. That's very general wording. Well, knowing what we know about how to read legislation, right? Knowing that you have to look at each word in the legislation, see if it's defined. Maybe you have to go to previous court decisions to see how courts have defined certain things. We should know enough to know that simply reading that and saying, oh yeah, I've got to keep people safe, that's pretty basic. That's not enough, okay? Simply reading through that, nodding our heads, it's not going to get us where we need to go. What we need to do is we need to go back to the definitions section to see if any of these words are defined, okay? And I can tell you that health and safety most definitely is defined. Okay, health and safety, as you can see right here, says includes physical, psychological, and social well-being. All right. Well, that's an incredibly broad range of different things that you are responsible for when it comes to ensuring the health and safety and welfare of your workers, not just physical, but psychological and social well-being. Okay. So you can see just how not simple this becomes when you actually look at what the Act is saying, and how saying that it's just a simple safety standard is really misleading. So we have the goals of the legislation now. We have the obligations on employers, supervisors, owners, workers. And when you put them all together, what you really see is that the legislation, the Act, Okay. Forget about the code, forget about the regulation. You see that the Act is set up to try and prevent any number of things from negatively impacting the physical, psychological, and social well-being of workers, and to prevent harassment from occurring. Okay. Those are the quote unquote basic safety standards that you have to comply with. All right. So I'm going to stop sharing that, and I'm just going to recap quickly. Picture the OHS legislation as a roadmap on how to get from point A to point B safely. The Act says, and the Act is the overriding piece of legislation, or it's paramount, as we say in law. These are the goals. Okay, that's the goal in no uncertain terms, to get from point A to point B safely, start of the shift to the end of the shift and home safely. It then goes through and identifies 10 different groups of players, okay, 10 different roles. And as I've said, you definitely fit within 4 of them, maybe more. And it says to those 10 different groups of players, essentially, listen, it's on you to make sure that you deliver on this goal of keeping workers safe. And if you don't, we've given OHS officers in the court some powers to write some orders, whether it's stop work, whether it's non-compliance orders, to issue some penalties, whether they're administrative penalties, $10,000 a day, or whether they're prosecution type penalties, which can be up to $500,000 per count. Okay, that's the Act. Now, the regulation and the code, which technically don't apply, are really the meat and the potatoes to the Act. Okay, they're the finer points, if you will. Or if we keep with this analogy of a roadmap, consider the regulation and the code, again, which don't apply. Consider them your satellite navigation system that essentially says, okay, we've got to get from point A to point B. We've got some general obligations here that say we have to do it. And if we don't, we're going to be in trouble. Now, here's what we think will be the best way for you to get there. Okay, and the regulation and the code goes through over 800 sections in so much detail that it actually tells you how many toilets you have to have per person at the worksite. But here's the thing, even though it gets into that much detail, as much as the legislature tried to capture every possible roadblock, washout, weather condition, animal on the road, etc., that's in the code, we're all drivers, and we all know that's simply not possible. You are never going to be able to plan out a route from A to B and take into account every single contingency. And that's why it's the Act that sets out the goal in the form of what's known as the General Duty Clause. And the players, including owners, supervisors, employers. And to be very clear, yep, director would fall under owner if it's, to David's question, director would fall under owner if it's the director that's registered on title. But director would most certainly be an employer and a supervisor and a worker. Okay. Whether you call yourself a director, a manager, a foreman, it doesn't matter what you call yourself. It's whether or not you fit within those definitions in the legislation. Okay. The Act sets out the goal, sets out the general duties on each of those different groups and says, listen, you have an obligation to fulfill that duty. If you don't, and that's a duty with respect to your workers, other organizations' workers, and people in the vicinity of your worksite, whether they be customers, clients, or members of the general public, you have that duty to do so as far as is reasonably practicable. Okay, and to identify hazards and keep hazards from presenting themselves or impacting those people, whether they're specifically identified in the code or not. If they originate from your worksite or in your buildings or anything along those lines, you're responsible for it. And if you don't deliver on that, guess what? You're going to be penalized. Okay, and so many people make the mistake of thinking that, well, the code doesn't apply, and so it's not really relevant. And even outside of the farming and ranching industries, so many people get caught up in, well, we complied with the code, so we're good. And I always use this example of something called hyperacusis. Okay, hyperacusis means you can't be around incredibly loud sounds, or not even incredibly loud, but a certain range of decibels, you just can't be around it. Now, the OHS code has details on what sort of decibel ratings are okay per 8-hour shift or per exposure. Okay, and in the OHS code, it has a certain threshold, and it says you can't exceed this threshold over an 8-hour, a 10-hour, a 12-hour period, let's say. All right. So suppose that we have an employer. Remove yourself from farming and ranching for a second. But suppose we have an employer that says, okay, well, we know that that's the requirement. You can't go above, I think it's 72 decibels. I stand to be corrected on that. But you can't go above 72 decibels. And the employer says, okay, well, we come in at 71. Okay, we come in at 71, we're good. Maybe it's 75, but in any event, we come in at 71, we're good. We're under that 72 threshold. Some organizations, some people out there think that because they are meeting that code requirement, they're good, they're solid, right? They're under that 72. But what people, or not everyone, understands, and is such a huge problem, is that the Act trumps the code. Remember where I said that you can't possibly take into account every set of circumstances, and that's why you have the general obligations? The general obligations trump those specific ones, okay? They're paramount in law, which means that your obligation to ensure the health and safety of your workers goes beyond just what the code says. So in our example, suppose you have a worker that has hyperacusis. They can't be exposed to anything above 70. The fact that the code says 72 is okay does not mean you are compliant if you have them working in that environment. You have to go above and beyond what's in the code because you have a worker that can't be exposed to above 70. And so you having it set at 71, that's a problem. You're in breach of the legislation. You could be held responsible for it. Okay, notwithstanding that you're in compliance with the code. And that's just an example for how people put too much emphasis on the code, even when it does apply to them. Now, one of the biggest mistakes that farmers and ranchers make is thinking that just because the regulation and code no longer apply, they're irrelevant. And that couldn't be farther from the truth. The requirements around hazard assessments and training and things like that are crucial to consider if you're actually going to accomplish the goals of the Act. The fact that they aren't technically applicable just means that you can't be charged for failing to do those things. But in the grand scheme of things, whether or not you do many of them, not all, but many, will be directly relevant on the assessment of whether or not you are taking all reasonable steps or necessary precautions. And you should really still be using the code and the regulation to help you assess that. I mean, common sense supports that, right? Just think about it. If you don't assess your worksite for hazards, or you don't provide any sort of training, both of which are requirements under the regulation and code, are you really doing everything that you can to keep an incident from occurring? Or are those things, regardless of whether they are mandated, things that should be incorporated into your health and safety systems? I mean, really, to ask the question is to answer the question. I mean, think about how the code came to be. I mean, even those working groups that the previous government introduced to make recommendations on how the code and the regulation should apply to farms and ranches when it was anticipated that they would. The code is the result of compiling years upon years of experience and insight into how to ensure safe workplaces, whether they're farming or otherwise. It's something that both OHS and the Crown work with regularly to frame their discussions and analysis, and all other industries. Okay. Do you really think that just because it technically doesn't apply, they aren't still going to look at it, or that the information in there is no longer valuable, that it won't be used to assess what reasonable steps are? So to David's point, so in short, the OHS Act itself can be thought of as an umbrella that covers off as broad a swath as possible. I love the way you put that, exactly, without getting into the weeds of the technical aspects of the code. That's exactly it. And to your point, David, when this UCP government talks about cutting red tape and we're making legislation that's not as prescriptive, what they really mean is we're not going to tell you necessarily how to do it in this much detail. You still have to figure it out. That doesn't mean what we've said in the past about how you should do it doesn't hold water or doesn't have merit. It just means if you find a different way to do it that still achieves the same end goal, you're not going to be penalized. We're not forcing you to do it this way, but you best come up with a way that still accomplishes what we think this way is going to accomplish. I mean, essentially what's, to go back again to our roadmap analogy, you're turning off by saying, well, the regulation and the code aren't applicable. You're turning off the satellite navigation, okay, so to speak. I mean, it doesn't mean that you're changing the end destination. You're just saying there's more than one way for farmers and ranchers to get to that end point safely. And more importantly, that they're not going to be penalized for finding another route. The key thing, though, is that you take ownership of that journey and that you're actually arriving at that end destination of having taken all reasonable steps and all necessary precautions to ensure the health and safety of workers and of one another. That's one of the biggest mistakes, is thinking that the Act just, well, the Act is basic and we don't need the code and we don't need the regulation. That's a huge problem. And that shouldn't be the approach that folks take to it, okay? The code and the regulation provide those finer points and give you the stuff to think about, right? So if that's one of the bigger mistakes, what are some of the others? Well, since this all came about through Bill 6, I'll share 6 with you, okay? With that one having been the first. These are 6 of the biggest mistakes or misconceptions that I see on a regular basis. So if that was number 1, the second is thinking that so long as you don't do anything wrong or that you're not negligent, you're going to be all right. Well, if that worker shoved their hand into that piece of equipment, that was their, I didn't tell them to do it, okay? There's this notion that it's not your problem if you're not the one that made the mistake. And I can't tell you how often I hear that, but guess what? OHS laws aren't really all that concerned with negligence, or more particularly with what went wrong. The question when things go wrong isn't what you did wrong in so much as it is what you did right. That's what you need to demonstrate, okay? You need to demonstrate what went right. And that's a distinction that a lot of folks fail to appreciate. Saying that you've done nothing wrong gets you nowhere. You need to show what you did right and the steps that you took that should have been taken leading up to that incident. And that brings us to the third biggest mistake, that being that there's this notion out there that it's not the end of the world if a person doesn't turn their mind to health and safety or misses a hazard assessment or 2, or, you know, things of that nature. There seems to be this idea that if nothing bad, quote unquote, happens as a result of that missed step or that missed hazard assessment, there's no harm or no foul because, hey, nothing bad happened. Everyone's still alive. But here's the thing. Although you may think that nothing bad has happened, when it comes time to tell your story, okay, when it comes time to explain all the good things that you did, all of those positives that you did to comply with that general duty clause, that missed hazard assessment sticks out like a hole in the wall, and it creates a gap in what would otherwise be a good story. And quite often in my experience, that gap is the difference between a finding of innocence and a hefty fine, or worse, incarceration. And yes, there are examples of incarceration even from right here in Alberta. And I'm happy to discuss that further at the end of the first hour here if we have any questions. But moving along, the fourth biggest mistake that I encounter from producers is this thought that WCB coverage or private insurance coverage somehow provides blanket protection from any and all costs, claims, and OHS liabilities. Yeah, WCB and private insurance will provide coverage to an extent, but that coverage relates to civil claims, not to regulatory prosecutions, fines, and penalties, and or the costs associated with defending those proceedings. And the reason for that being, quite simply, is because regulatory defense and penalties coverage is considered contrary to public policy, as it's essentially providing coverage for breaking the law. I mean, wouldn't it be great if we could get insurance for speeding tickets? We can't, because it goes against public policy. And the same can be said for private insurance. And yet this distinction between what is covered and what isn't covered is still a source of confusion, and not just among farmers and ranchers. At least once per month, I would say, I find myself explaining the difference to a client outside of the farming and ranching industries. And needless to say, it's a very rude awakening when they discover that they may be on the hook for a maximum fine of up to $500,000 per count for a first offense. Okay, so don't kid yourself and think, oh, we got WCB, we got insurance to take care. It doesn't take care of it. It doesn't take care of the OHS side of things. Coming in at number 5 is the belief that because only the Act applies, OHS only has limited powers, or they can only come out to my property if there's a fatality. I'm doing a lot of this today. Here's the thing. If you sat in on any of the initial town hall meetings that were put on by OHS way back in December of 2015, when all this first really got started, you likely heard the exact opposite of this continuing misconception from none other than OHS officers themselves. They, in those town hall meetings, came straight out and said, yeah, we'll come out whenever. Just because the Act applies doesn't mean we can't come out, doesn't mean our powers are limited. We'll come out, we'll enforce, okay? We have the authority. But here's the thing, as the Bill 6 debacle, as I'll call it, played itself out over the following weeks into 2016, that initial and quite correct information was gradually replaced with this rhetoric of limited powers. And as a result, it's the limited powers misconception that is still regularly reiterated among various players and media outlets. And while OHS does admittedly have a vast degree of discretion in how they choose to approach matters, suggesting that their powers are somehow limited because it's only the act applies, could not be farther from the truth, particularly when you consider that in certain situations, they actually have more power than the RCMP or than your local police jurisdiction. Okay. If you take a quick scan through the existing regulation and code, and I say quick because it's pretty thick, but you'll see that there's not really anything in there in either the regulation or the code that deals with OHS officers, the power that OHS officers have, or any of that. And that's because OHS officers don't get their powers from the regulation or code. You know what they get it from? They get it from the Act. And it's the Act that applies. Now, without the code, the OHS officers may not currently be able to write an order with a degree of specificity that says, you're not complying with this section of the code that says this, and we want you to fix that. But they can most certainly write that same order just without that level of specificity. They can still write stop work orders, stop use orders, or non-compliance orders saying, hey, you're not doing everything you need to be doing here to protect the health and safety of these workers. They can and do write those orders without the need for the code in place. Okay, in very simple terms, an officer only needs to be of the opinion that things are not safe. Once they have that opinion, they can write an order that farmers and ranchers stop everything, essentially grinding all of your operations to a halt, or that they stop using a certain tool or a piece of equipment until you take certain measures that they deem appropriate or necessary to remedy that unsafe or dangerous condition. And it's only then that work can resume, whatever those measures might be. Okay. Now, not only that, but an OHS officer's ability to write stop work orders or to visit your farm or ranch, it's not limited to situations following an incident or an accident. Okay. That's not how it works. On the contrary, the power to write stop work orders and to visit a farm or ranch comes from an OHS officer's ability to inspect work sites that are, again, found in the Act. Well, you have a work site, okay? OHS powers to inspect that work site, to write stop work orders, found in the Act. The only requirement or the only limitation on that is that they show up at what's considered a reasonable hour. And that's a far broader power than you're continuing to hear about at different information sessions in the media, et cetera, where the common belief seems to be that OHS officers can only come onto a farmer or rancher's property to investigate, ask questions, or seize things following an accident. That's just not true. Okay. Now, granted, while OHS isn't by all counts currently engaged in the process of writing orders to farming and ranching operations or performing proactive inspections, okay, that doesn't change the fact that they currently have the power to do so, and it's something that will inevitably happen in the future. The question isn't if they can, it's when they will. And I can tell you, speaking through experience, I've had a handful of clients where OHS has come out, farming and ranching industries, where those types of orders have been written. Some of those orders we challenged on various grounds, some of them not. Okay. But to think that they only get involved when there's a fatality is just, it's completely wrong. And on that point is this notion that even if OHS does come out to my property, they can't actually go into my house. That's just plain wrong. Okay. Is your house a work site, as that term is defined in the Act? I'm not going to pull the Act back up again, but work site essentially means where a worker is or is likely to be engaged in an occupation. Okay. One of the big issues with Bill 6 when it was first introduced is that very early on, OHS officers noted that, yeah, in certain circumstances, we're going to enter individuals' private residences. Okay. And although that notion was quickly quelled and the concerns dealt with, given the incredibly broad definition of work site in the Act, there's a real possibility that a farmer or rancher's home may not be off limits. Now, some, myself included, might go so far as to say it's more so a probability, but either way, it's certainly not clear, particularly since OHS officers, unlike RCMP or police officers, don't actually require search warrants for their authority to enter. Now, on the contrary, for the purposes of the Act, which again is the part that's in force, OHS officers can enter at any reasonable hour onto any work site and inspect that work site. Or in the event of an accident, they can attend at the scene of the work site. Okay, it's a little bit different. There's not that reasonable hour requirement in the event of an incident. So they could show up at 2 a.m. if there was an incident. Now, contrary to what a lot of people think, there's no specific exemption for private residences, at least not in this context. What happens in the case of a home office, let's say, where workers are coming or going, or if files or equipment, whether it's coveralls, gloves, safety glasses, etc., are stored inside a closet or a bedroom or a basement, or taking it one step further, something that we always used to do back home during calving season, if a sick calf is brought into the garage one evening to stay warm, okay? In any one of those situations, the private residence fits within that definition of worksite, and OHS would be entitled to access. And I've got to tell you, I'm aware of it happening on more than one occasion. The one caveat that you need to be aware of is that in 2018, through some other changes, there was a requirement put into the OHS Act now that OHS officers obtain consent before entering into a private residence. And I think that the reason for that change speaks for itself. If they weren't entering into private residence or had no intention of doing so, why would they ever need to put that qualifier into the legislation, right? Now, how OHS actually approaches that is still a bit of a work in progress. It will inevitably involve charter challenges and things of that nature. And it's one of the details, one of many details that will no doubt be sorted out in the months and years that follow. Okay, this legislation, how it applies to farms and ranches, is still relatively new. All right, and so it's going to take a little bit of time until we see how the courts respond to it and what sort of jurisprudence or legal cases authorities come out that give us a little bit more insight on that front. But rest assured, those cases are in the works. Okay, the OHS department on their website lists off cases that are active cases, active prosecution cases. I can give you the link for it if you want to go and have a look, but you'll look through there and you'll see some farming and ranching operations that have been tagged. Okay, I have clients that have been tagged. We're dealing with this as we speak. So I mentioned top 6. Rounding out the top 6 is really falling victim to the misinformation that's out there, even from those with good intentions, whether it be from the media, OHS officers, your neighbors, or others. I mean, there are so many things that I can group into that heading, and I think it might just be better for me to leave it to the second half of today's discussion in the context of answering some of your questions. Okay, so I'm going to park that there, but I don't want to just be all, well, this is stuff you need to be alive to. What do you do with all this information now? Okay, well, here's my hope. My hope is that this discussion and the question and answer that's going to follow will help you identify and address some of the lingering misconceptions about Bill 6 and occupational health and safety legislation as it applies to farms and ranches, okay? The changes that it introduced, the changes that have followed in subsequent legislation, what's happening out there. Big part of the farming and ranching community being ready for and responding to what's happening is understanding what the legislation means, what the act means, both in a legal and in a practical sense. Okay, education is absolutely key, but education needs to be accurate and it needs to be based on what actually is, as opposed to the rhetoric and misinformation that continues to permeate the discussion in both the media and elsewhere. Due diligence, okay, you hear that term a lot. Due diligence is the standard that you're reaching for in the health and safety world. And it's really all about writing a story each and every day through the policies and procedures you put in place, the assessments you do, the interactions you have, the example you set. It's recognizing that you hold the pen in the writing of that story and that the day will come inevitably when you have to tell that story, whether it's to an OHS officer, a judge, a family, a victim's family, the media. When that day comes, you want to be able to get up that morning, look at yourself in the mirror, give yourself the wink and the gun or the double guns. Okay, you know what I'm talking about, the wink and the pew pew, and leave the house feeling confident. Okay, you want to be able to leave the house feeling confident that you can truly say you did everything reasonably practicable to keep that incident from occurring. If you're leafing through in the telling of your stories and there are blank pages in your story where you didn't do something you were supposed to do, or you're looking down, kicking the dust and saying, aw, shucks, that's a pretty good sign that there was more work to be done and that you need to get on top of that stuff now. So that's kind of the takeaway, is getting on top of this sort of stuff, understanding it, and then working through it, and putting those wheels in motion. We're at the end of the first hour here. So I'm going to basically take a little bit of hey, I'm going to grab myself some water and have a little bit of a 30-second break. Not sure if there's any questions in the chat box, but I'll hand it back over to Kaya because I see that she's there. I'll let her
Thank
start that off.
Okay. Thank you so much. Wow. Definitely some of it, you've talked about before, but some of that was new. So the whole thing about going into the house, my goodness, never thought of that.
It's been interesting. And in fairness, I will say, in fairness, the circumstances where OHS has actually been very good about whether or not they have consent. Now, I don't think they had legal consent to enter, for what it's worth, but in those circumstances where they have, as soon as there was the slightest hint that that consent had been revoked, they were out of there. Right. And it left the farming and ranching couple actually at the time thinking, wow, we really scared them. And I'm like, well, that's not really what happened. They just have to be in there with consent, and you kind of made it clear they didn't have it. So.
So I'm just going to pull up some of the questions that we did have submitted. Maybe the first one that I will pose is how all of this then applies as well to colonies where we have so many family members working on it, where they have multiple kind of businesses going on. What would you say to them? Because I know a lot do believe that it doesn't apply to them as well.
Well, and that's one of those things where, to my sixth point, there's a lot of misinformation out there. And I understand why a lot of colonies think it doesn't apply, because in the very early goings on, it was, well, it doesn't apply to colonies. It doesn't apply to colonies. But the legislation doesn't actually say that anywhere. Okay. It doesn't apply to colonies if you accept or you believe that everyone on that colony falls within that family designation. And I mean, I grew up next to a colony. We actually, we farmed next to each other. We chatted, we worked together, et cetera, that sort of thing. I know that's not how it is. Okay. Not everyone is going to fall within that familial tie that's necessary to bring that exemption about. So you're really playing with a little bit of fire thinking that, well, it doesn't apply to colonies. It does apply to colonies. There is no set exemption carved out for a colony. The other thing, or the other aspect to that is you mentioned, if you've got different sort of aspects of work, suppose that you've got farming and ranching work over here, and maybe you've got a different type of business over here. I won't make any suggestions on that, but something that's not necessarily farming and ranching related. The exemption does not just apply to the entity. Okay. So let's use it in the context of not necessarily a colony, but a corporation. So the corporation owns a farm. All right. The corporation has a livestock operation through a certain amount of acres, and it also has a landscaping operation on the side. Well, it's not that the entity is exempt, it's the work that is exempt. So any single time you're talking about the exemption, you need to look at the work in question, not the company, not this is the party that is overseeing everything, et cetera. It's what is the nature of the work. And so if the nature of the work is raising and maintenance of livestock, that's caught as a farming and ranching operation. If it's landscaping, that's not. Even though it's the same company or the same group that's doing both, only one of those activities is exempt. So really focus on the activity, not on the on the ownership group, so to speak.
Thank you. So Kent Erickson has a question. Don't know if you want me to read it out or.
That's all good. I'll going back to 2015, the biggest fight that many farmers and farm groups pushed was education and awareness of family farms. How does legislation enforcement make family farms safer? Yeah, this is one of those questions, and I've got to say, Kent, like this is where I say a lot of the rollout initially was, well, family farms, we've got all of these incident rates, we've got to protect the kids, we've got to do this, we've got to do that. Yet then when the legislation passed, it had the family exemption. So it's like, okay, well, all of the reasons you said that this legislation was necessary, you kind of backed out when you passed it. So if that's why it was necessary, why is the family unit exempted from it, right? And so that's where I say the real reason, or the core of that issue, in my opinion, ties back to you had all of these different types of organizations that were benefiting from the exemption. And the real challenge was to get them caught so that they couldn't rely on the exemption. It wasn't so much, and again, maybe this is the pessimist in me, but it wasn't so much directed towards, we got to protect the kids, we got to keep the family farm safer. Now, that being said, inevitably, there is an opportunity here to improve the family farm. Just because it doesn't apply to you because the exemption applies doesn't mean you should just be like, oh, great, it doesn't apply, we carry about our business without anything. I mean, I personally think back to some of the situations that I was in growing up, and I just shake my head and I'm amazed that I'm here today having this conversation for what it's worth. A lot of risks, let me put it that way, a lot of risks and a lot of things that, as kids or growing up in the midst of it, we just didn't even consider would be a potential problem, right? And I look at it now and I'm like, yikes.
So one question that was posed recently, OH&S officers have said that fall protection is a gray zone in agriculture. What would you say to that?
I'd say it's garbage. I mean, I'm going to be very upfront in terms of my responses with this, okay? But to say that it's a gray zone in agriculture, not really. I mean, in the sense that the OHS code says, listen, if you're working above 3 meters, you have to have certain requirements that are engaged, okay? You have to have a certain type of fall protection. You have to have a fall protection plan. You have to have all of these various things in place. Now, the code doesn't apply to farming and ranching operations. But does that mean it's somehow a gray area that, well, who knows what you, no, it doesn't, okay? That 3 meter requirement was put in as a result of much research, studies, et cetera, that said essentially falls from above that height create a heck of a lot more damage than falls from below that height. So anything above that height, you have to have these steps, you have to have guardrails, et cetera, in place. To say that, well, it's a gray area, that just confuses the issue. There's no gray area. You still, as an employer, farmer, rancher, otherwise, are required to make sure that people are not falling from a height, whether it's 3 meters or otherwise. And so whether the steps you take are guardrails and you do it at 2 meters, 5 inches, or you do it at 3 meters, 1 inch, you still have to take the steps. It doesn't necessarily have to be those that are set out in the code specifically, but if it's not going to be those ones, it has to be the equivalent of that that's going to offer essentially the same level of protection.
Thank you.
What triggers OHS to investigate and or come out? A fatality or else? Well, that's a really good question. I mean, a fatality is a given. Okay, a fatality, it's a given that they are going to come out. Can they come out short of a fatality? You betcha they can. What else would be a mandatory visit? Things are a little bit different with COVID. I'm going to be upfront on that because a lot of these they're doing via, conversations like this on WebEx and different platforms. But if a complaint is received by OHS, anonymous or otherwise, they're coming out. Fatality, they are coming out. If there is a number of instances, and it varies with respect to whether it's a number of instances or color ranking, et cetera, but if you've had a certain select number of orders issued to you in the past, they're going to come out. If there's a targeted inspection, now there hasn't been one with farming and ranching as of yet. I think that's, that we'll wait and see what happens on that front. I think that's politically charged for a variety of reasons, but a targeted inspection, they would come out. But those are guarantees. They're going to come out and they're going to chat with you and they're, going to do their inspection. Or in the course of a fatality or a serious incident, okay, a reportable incident, doesn't have to be a fatality. It can be just a serious incident. Those are givens, but they're capable of coming out at any point in time, right? If they're driving by your farm and they see you riding around on the back, looking into the hopper, seeing what's going on, guess what? They can drive onto your field and stop that. Okay, so there's nothing that prevents them from coming out at any point in time, except for people power, so to speak, in the sense that they just don't have the resources to be out there policing it 24/7.
Okay. So another interesting point is everybody focuses so much on the act and provincial legislation. Is there anything you would like to say with regards to like the Westray law as it might apply to farms and ranches as well?
Right. Well, and I mentioned earlier, there are cases even here in Alberta where people are going to jail. Okay. And the Westray law, people talk about it as the Westray law. Bill C-45 gets a lot of references. And I think in large part it's because people don't remember it's section 217.1 of the criminal code, but it goes back a while now. And essentially what it did is it created a duty at law for workplaces. Again, don't consider yourselves special because you're a farming or ranching operation. It applies to you regardless. Okay, there's no exemption in the criminal code that says if you're a farming and ranching operation, you're not covered by this. And what that law says is essentially if you are responsible for directing the work of others and you are negligent, criminally negligent, where you show willful disregard or wanton recklessness, you can be found criminally liable for that behavior. Okay, so there's no exemption carved out as there is in the provincial legislation for it, but it still applies. And a couple of interesting pieces of information on this that I don't think everyone necessarily understands, but back in 2017, the provincial government here passed signed off on a memorandum of understanding. The regulator OHS and RCMP/policing agencies throughout Alberta signed a memorandum of understanding that said, on a go-forward basis, following every single fatality at a workplace and serious incident, depending on its nature, the RCMP or the policing agency of that jurisdiction will take the lead in the investigation. And that was a very significant development, because prior to that, what you had was OHS investigating these things. And without pulling any punches, OHS was not trained to do a criminal investigation. And so when OHS would complete their investigation, forward the file off to the Crown's office to see whether or not charges should be laid, the notion of charges being brought under the Westray law or under Bill C-45 or Section 217.1, the notion of criminal charges didn't really have a whole lot of hope in succeeding, because the investigation wasn't done in a way that evidence was properly protected or preserved, and all of these criminal elements that would be necessary to bring a criminal prosecution just typically weren't there. And through no fault of their own, OHS officers just didn't have that training. Now, over the course of the past however many years, there's been this movement to say, you know what, we have that criminal law there. Why aren't we using it more? It's only been used a handful of times. And the most well-recognized time being a case out in Ontario, where a project manager / supervisor a decade ago, actually on Christmas Eve on 2009, had an incident. 4 people were killed, 1 seriously injured, and he ended up being sentenced to just under 4 years in jail. And so that really sparked the discussion of, well, why aren't we seeing more of this? Why isn't this happening more, et cetera, et cetera, et cetera? And when I was at the Crown Prosecutor's Office, we would regularly, at least once a year, meet with other jurisdictions and say, okay, what's happening on this front? Where are we at, et cetera? So in 2017, when this MOU was signed and you now have RCMP or policing agencies taking the lead, that whole problem of the evidence isn't there for a criminal charge or a criminal prosecution is no longer a problem. And I think in the course of the next 6 to 8 months, you're really going to start to see how that plays itself out. You're going to start to see more of those matters headed towards criminal negligence charges. And on that same, in that same breath, I mentioned in Alberta, you've seen already this happening. Well, it didn't happen under the criminal code, but there was a case going back. It happened out of Edmonton, not farming and ranching, but still, just because you're farming and ranching doesn't mean the penalties are somehow different. Okay. It happened on the west end of Edmonton, and it was a guy digging out a basement, and he had hired someone to come in and do it. And he kind of basically picked this person off the street, threw them in a piece of equipment and said, dig out this basement. They didn't have any shoring, bracing, any of that. It collapsed on this individual and he was buried alive. And it just so happens that this happened at a time that Global Edmonton was still all super excited about their helicopter. And they went out there and essentially broadcast the recovery efforts or the rescue efforts, which later turned into recovery efforts, live on their 5 p.m. newscast. So it got a lot of media attention, et cetera. 2 years later, less a few days, that particular individual was charged. That particular individual went to court, did not think it was appropriate that he should pay a fine of 60 or 70 some thousand dollars, and instead argued for a lesser sentence. And even though the Crown prosecutor in that case wasn't asking for it, defense certainly wasn't asking for it, the judge came back and said, listen, you just don't get it. The legislation is set up to put obligations on people like yourself that have control and direction over work. And the fact that you don't get it and that you were as negligent as you were here, I don't think a fine is appropriate. And I'm paraphrasing here a little bit from the decision, but the judge essentially came out and said, listen, this is a message not just to you, but to supervisors across the board and for those that employ other people. If you are going to bring other people onto your work sites and you are going to take over control direction of them, and you're not going to take it upon yourself to figure out what that means from a legal standpoint or how to do it properly, you're going to find that this notion of a slap on the wrist fine is no longer the default. You're going to find that the default position is incarceration. One life pays for another, so to speak. Now, we're not talking a life sentence in that particular case because it wasn't under the criminal code. It was only a possible 6-month prison term along with the fine because the provincial system is set up a bit different, but 4 months in jail for that particular individual. Long-winded answer, and I apologize for that.
Thank you. So we have questions both on the chat side and the question and answer side now.
All right. Is OHS working at arm's length with WC regarding injury incidents? Yeah, kind of. Yeah, kind of in the sense that they're technically 2 separate bodies, but particularly now with COVID and what's happening with COVID, they interact a lot with respect to contact tracing and that sort of things. or that sort of thing. So, I mean, OHS will inevitably ask for the WCB reports. It's not as though something comes into OHS and it automatically gets fired across to WCB unless that's changed from my time there. But they do, they do have interactions. Let's put it that way. Depth of a scope of an investigation that has to be followed after fatalities happen can be concerning. That's a really good question, Kent, and I'm glad that you brought that up, because here's the thing. When I talk about misinformation, one of the things that I said is OHS officers can be the source of misinformation. And it's true. They're trying to understand this legislation as well. They're trying to interpret it, but they're not the courts, right? They're not the ones that whose interpretation or decisions on these things is going to carry the weight at the end of the day. That's going to be a court decision. Now, that being said, of course, you're going to follow and pay attention to what they're saying because they are the regulator, right? So I'm not saying you dismiss it entirely. But one of the things that OHS does following a fatality or a serious incident is they will come out and under the legislation, under the Act, you are required to draft and provide an investigation report, an incident report, okay? And that incident report, when OHS asks for it, will say, we want you to provide us with a copy of your investigation report. We want you to identify the root causes, the contributing factors, do a taproot analysis, et cetera, et cetera, et cetera, et cetera, et cetera. And they will also, pursuant to their power to ask for information, they'll issue a demand to you. And for those of you that have never seen it, it comes on a sheet. The top of it's a chart part, and it says your legal description of your land, who you are, some details about the date, the time that the incident happened, who the investigator is, and then there's 3 columns. And in those 3 columns, they'll list off what's their statutory authority for doing what they're doing. And then they'll say, this is what we want you to do. And in the context of the demand, they will ask you for a whole host of information. 2 things about the demand, about the demand and about the investigation report. First of all, statutorily speaking, all that they are entitled to in that investigation report is circumstances giving rise to the incident and corrective action taken. Okay, that's all they're entitled to. They're not entitled to taproot, root cause, contributing factors 15 through 35. They're not entitled to that, but they'll ask for it because if you give it to them, hey, no harm, no foul, right? And one of the mistakes that a lot of organizations, farming and ranching or otherwise, make is thinking, well, we didn't do anything wrong, so we're going to give them everything and we're going to demonstrate to them that we didn't do anything wrong. And while that might seem like a good idea, here is the thing. OHS is not there to be your friend, okay? They're not there to clear you. They're there to see if you stepped offside of the legislation. And as I mentioned earlier, when it comes to people, power, and resources, they're pretty tapped, okay? They don't have a lot available. And so if you think that you're going to give them this information, they're going to sift through it, find all the good stuff, and they're essentially going to build your defense for you to some degree, or that they're even going to do an investigation that's as complete as you might like it to be, you're mistaken. Okay, and that's not a slam on OHS. It's just that's the way it works. They're coming out there to do 2 things: to figure out what happened so as to prevent a recurrence, and to figure out if you stepped offside of any one of those sections amongst those 102 sections. They literally take out the blue book and they leaf through it and they say, okay, this one, did this happen? Did this happen? Did this happen? Sometimes you want to give them information in addition to what they're requesting, whether it's in the course of your investigation report or in your demand, okay? Sometimes you want to make sure that they understand what happened because it's clear to you from your conversations with them or from the information that they're asking for that they're on the wrong path. And there's an opportunity there for you before it ever goes to the Crown's office to correct that path and to try to make sure that you can stick handle through it as best you can, divert attention elsewhere, or make sure that they understand that, no, you actually did do everything you were supposed to do, okay? Sometimes you want to do that. But most often what ends up happening is you give them all of this information and it just simply raises more red flags because something here wasn't filled out properly, or this doesn't make sense, or this contradicts this, or any number of various factors. The charges or the penalty still comes, and then counsel comes in like myself and says, okay, well, let's find something that we can point to say they made the wrong decision. Oh, you gave them everything? Okay, well, this is going to be tough now because, as you can imagine, lawyers don't like to admit that they're wrong. And so if it hits the level of the Crown prosecutor and the Crown prosecutor's laid charges on the basis of everything that you've given already, to come in and say, no, you just interpreted that wrong, is a heck of a lot more difficult than saying, well, look, if you'd have seen this, this changes things, right? And we can sort of trump that up and explain that this way now, which you maybe didn't understand to begin with. In terms of the demands, OHS, I've seen them ask for everything from banking records to, any number of strange requests. They're not entitled to that, okay? They're entitled to information that goes to the cause of the incident, okay? or again, corrective actions that need to be taken, things along those lines. Sometimes they're asking for more information because they're setting the stage for a prosecution or for a penalty. It's important that you have an understanding of that. And I want to say this before I sort of leave this topic, but when you do these investigations, it's so super important. And this just isn't myself patting myself on the back here, but you want to get counsel involved right from the outset, okay? Because bringing in counsel allows you to claim privilege over your investigation, i.e. we clamp it down and nobody sees it but you and I, unless we want them to. So it's there that you do this broad brush, intensive analysis in terms of what went wrong and come up with the 15 to 35 different contributing factors. That's where you do that. But you're able to learn from that what went wrong, what changes you need to make, what sort of flags are there. But that doesn't mean you give it to OHS. You do it in that privileged area or that privileged arena. And then from that, you water down or you sanitize, as I like to put it, the version that you give to OHS that goes through and says, okay, this removes all the inflammatory stuff, all the stuff that's not relevant, and it gives them what they require under the legislation. Okay, so there's ways that you can comply, but that you comply without essentially selling the farm, so to speak. Okay, and that's the way that you want to approach each and every one of those instances. And I can't tell you the number of times that when I'm retained initially and we're able to help navigate that process very early on, there's a much more positive result than bringing in myself after charges have already been laid and saying, okay, now fix it. Because at that point in time, the cat's out of the bag, proverbially in many, many ways. I think that's it for the ones in the chat box.
Okay.
Oh, I see. There's a little question and answer thing too.
Okay.
Just saw that. Regarding fall protection in the eyes of OHS, are cages on ladders of grain bins adequate fall protection control measures? I can't speak to that. It would have to be dependent on the exact facts of the or of the case in front of you. The grain bins getting up to that stage, number one, are, there's that issue. And then what happens when you're up there? What does that cage look like, et cetera? It's the best I can offer on that is maybe. It just depends on the specifics that you're dealing with. Beth, is there a website that we were able to access the current investigations being completed by OH&S or industry notifications? You know what? You can sign up for the OHS newsletter. You can do that. And they typically have some good information in there. In terms of the charges, I'm actually going to drop that into the box right now, just what the website is. So you can follow that link. If you search Alberta OHS charges, you'll get that as well. And so you get a little description there with respect to what's happening currently and what's a live file. To Maria, to your question, is it adequate fall protection? It's a good step, let's put it that way, but it just depends on everything else that's happening there.
Okay. So some of the other questions that we did get in advance. What are your thoughts on the changes to legislation that occurred in January of 2020 for farms and ranches? And will the changes coming up in 2021, how do you expect those to affect farms?
I think the 2020 ones, I think let me put it this way. I like the notion that the legislation isn't as prescriptive. Okay, as defense counsel, I like the fact that you're not going to be penalized for stepping offside of this provision of the code, that provision of the code, this provision of the regulation, et cetera. But if I'm honest and upfront about it, removing the code requirements and removing the regulatory requirements or the regulation requirements in the way that it's happening and the way that it's presented, I think has created a lot of misinformation and a lot of confusion. And people seem to think that they can just wash their hands and say, oh, code regulation doesn't apply to me. We just have to do what's basic. We just have to do the general stuff. And that is a very, very dangerous premise to be coming from. And, I think it's a bit of a disservice in many ways, notwithstanding that it's really helping farmers and ranchers because it's saying we're not going to have to be so prescriptive about it. but it's now kind of created this false sense of security that because these things don't apply to us, we're good, or we don't have to do as much. Or, and I think it was David that mentioned earlier, the act is really the umbrella. The act is where you have to do the most. The code is just the specifics of it. And so the act trumps the code. And if you're not doing more than the code, you're going to have a problem. But now there's this sort of false sense of security that's out there because they're regging the code no longer apply. So I think it's helpful, but at the same time, I think it's a bit of a double-edged sword because it goes both ways and it's led to this misunderstanding. In terms of what's happening in the future, I think there's a lot of good stuff in the changes that are going to take effect next year, not the least of which is this whole notion of PSIs and what is a PSI and what isn't a PSI and kind of the garbage for what it's worth that went along with that. That's going to be dealt with, and I think that's fantastic. I think that this work refusal side of things and what constitutes a legitimate work refusal versus not a legitimate work refusal, and how the legislation and the act in particular in many ways was weaponized in terms of what came out of 2018. I think that the changes we're going to see take effect later this year are really going to remove a lot of that weaponization element. And I think that's going to benefit everyone, whether you're farmer, rancher, or other industry players. So there's a lot of good stuff in there. There's going to be areas without a doubt. I think one of the ones that jumps off to me right off the bat for farmers and ranchers is the new owner obligations. The new owner obligations are pretty intensive, and I don't think anybody's really cued into that as of yet. But as owners, you are going to be responsible for identifying hazards and bringing that to the attention of all workers. Okay, not just people that you have or third parties coming on to your site. If you hire a company to come on, maybe you bring on a subcontractor, you're still going to have the obligation, the way that the legislation is worded, to alert those workers of that subcontractor to the hazards on your work site. So, for those of you thinking, hazard assessments, hopefully the first part of this sort of discussion said, oh, you got to do them. But this really cements that for you, because again, it's not found in the act, but now it is. Now it specifically is going to talk about that and that obligation moving forward.
So you touched on PSIs. Can you explain those for us?
Oh, I wish I could. I genuinely wish I could explain what they are to you, but I don't know. And it's, I say that somewhat facetiously or somewhat tongue in cheek, but the whole notion of PSIs, I will put it this way, and I'm gonna speak somewhat off the cuff here because I don't have the exact figure in front of me, but ever since they were introduced, they've been problematic, okay? Because the definition in the legislation didn't really make sense. And so OHS came out and OHS said, here's how we interpret what a PSI is. Essentially, it's one of two things. If there was a hazard that you didn't recognize or properly control, then that's a PSI and it needs to be reported. Or if it was a situation that required medical attention beyond first aid, that's a PSI and that needs to be reported. Now, those were the first two sort of rough interpretations that they gave on how to approach these things. And they set up a website, and you would click through the website and it would say, oh, you're trying to report a PSI. Let's see if you need to. Are you an employer? Are you in Alberta? And then it would ask you questions. And one of the questions would ask, or one of the first questions it would ask on the very first page was, did you require medical assistance, or was first aid required, or something to that effect? I can't remember exactly what it was. Now we're going back a few years, but you would click yes. And as soon as you clicked yes and you hit the button next, it said, this is a reportable PSI. And if you looked at what they said their own guidelines were, it wasn't a reportable PSI. So they had that going from the very start, and it just didn't make sense. They tweaked it. I think they've tweaked it 4 or 5 times now. And it's still problematic the way that they've got the definition. They still tie it back to, we failed to identify a hazard. Well, if you failed to identify a hazard, that's actually a breach of the legislation. Now, granted, it's under the code, so it's a little bit maybe different in the farming and ranching context. But saying, I failed to identify a hazard, I have to report this. Well, you're essentially reporting that you broke the law. And that goes against a whole host of charter rights, conscriptive evidence, et cetera, et cetera, et cetera. So I have a problem with that. And then the way that they define it as something that could have led to something, could have led to a reportable, for example. I know that was in there at one point in time. Well, if the hazard presented itself and the controls failed, could it have? Well, it didn't. So how could you say it was likely to have done it? It didn't. Obviously, the controls worked to some degree. So it's kind of a bit of a mishmash mess for what it's worth in terms of what an actual PSI is, or legally speaking, OHS has what they consider it to be. I'm not going to quote that because, again, I know it changes so frequently, and I don't know what the most recent version of it is. I will say this. I have clients that have me on a retainer solely for the purposes of assessing whether or not something is a PSI when it happens. And the good thing about PSIs is when you have a reportable accident or incident like a fatality, that has to be reported right away. A PSI doesn't have to be. Now, I'm not saying that means you sit on it for forever, but it means you give some thought to it, you do some assessment, you call me and we talk about it and we say, is this something that we want to kickstart that process on, or is it not? Because the timing, notwithstanding that OHS says, oh, we still expect it to be reported as soon as reasonably possible, the legislation doesn't say that. Okay, that's one of those things that OHS says, we want you to do this, but the legislation doesn't require it. Within a reasonable time, sure. Okay, but it doesn't have to be quick. We got to report this to OHS. We got to kickstart this process. And the reason you don't necessarily want to start that, I know there are some folks out there that think, well, we want to report everything just to be on the safe side. Well, do you really not think OHS is going to do anything with that information? Okay. I mean, I can tell you right now, I have had clients outside of farming and ranching that have faced province-wide stop work orders, shutting down 26 to 30 odd sites because of information that OHS had on their file. Okay, they have an online database or an electronic database. It's called Dash, and complaints go in there, anonymous or otherwise. Any single interaction that you have with OHS goes in there. Guess what? Reported PSIs go in there. And what I've seen happen is OHS use that information to subsequently issue orders such as province-wide stop work orders saying, well, golly gee, we've had 10 run-ins with you over the course of the last 2 years, whether they were anonymous, whether they were inspections, whether they were PSIs, and 8 of them deal with fall protection. Pretty clear to us that there's a danger at your work sites with fall protection, so we're going to grind work to a halt. Okay. I mean, we appealed those types of orders. We were successful on the appeals, but you should know that that information is used for a purpose. There's that purpose. There's also the purpose of when they're assessing penalties. Okay. Generally speaking, if you're looking at an admin penalty, if you've got a clean record, nothing else has happened, depending on the nature of the breach, you're going to start at about $2,500 per occurrence. Okay. On the $10,000 scale. If you have a list of different interactions where you've had the exact same PSI reported, let's say 3 to 5 times over the course of the previous year, that sends a message that you're not getting it. And maybe instead of starting here on the penalty scheme, we start up here, right? So that information is used. Just be very, very alive to that. What's happening with PSIs? They are essentially changing them over, okay? So you still have to go through and deal with it. There's a little bit of back and forth right now as to whether or not they're still going to have to be reported. I don't see it how it's written into the legislation. I don't read the legislation the same way that the government does or that some of their spokespeople have. And I know I'm not alone in that. So that's something that you'll definitely want to follow up with and, get some one-to-one advice on in the future.
Great. Beth has a question in the Q&A box.
An employee would like to bring their child to work with them. If there were to be an incident involving a child, would the OHS Act apply, or would that fall into the criminal code only? Would like to be able to. It would have to depend on your work site, Beth. I mean, if your work site is, if you were covered by the legislation, when you bring that child to work, that child, regardless of whether or not they are a worker, is someone at the work site, right? And so you now owe that obligation to protect them from hazards that would emanate from the work site. Okay, so if the OHS legislation applies to you because the farming and ranching exemption doesn't apply, i.e. you don't fit within the definition of a farming and ranching exemption, and or depending on your payment of wages, it's just not available to you, such that that provincial act applies, then yeah, you know what, it's going to fall under both the provincial act and the criminal code. And that comes about as a result of a case out of Calgary a few years ago. If y'all remember when they had the is it Big Valley Jamboree here? Yeah, and that's down at I always get confused on which one is in Saskatchewan and which one is in Craven and whatever else. But in any event, at the Big Valley Jamboree, they had the stage collapse a few years ago. And what ended up happening is charges were laid under the OHS legislation. Those charges were ultimately pulled. But as a result of that same windstorm at an office tower that was under construction down in downtown Calgary, some materials flew off the top of that roof. Stuff's always flying off of buildings downtown Calgary. I don't know why. Can't chalk it up to the Chinooks, but stuff flew off the roof and killed a little girl. I think she was 5. She might have been 9. I can't remember. A little girl named Michelle. And under the legislation at the time, because it didn't relate, or the OHS legislation didn't capture people that weren't workers, the best that they could do was a very, very minimal fine under different pieces of legislation. And so government got together, legislators got together and said, we need to change that. And so now if that situation were to happen again, or if a situation or an incident were to happen in your scenario, such that the legislation applied, the fine would be up to $500,000 per count as a result of that incident, even though it didn't involve a worker, even though it involved a member of the public, because it was a hazard that came from the work site.
Okay. So based off of your experiences, what are some key things farms should ensure they have in place for safety?
It's a very involved question. I think the big thing is just understanding. There is so much misunderstanding out there. The first thing you got to do is you got to get a good handle on how the legislation applies, what the act means, what your role in it is. And from that, you've basically got to get some type of a system in place. Okay. And I've heard people say, well, I'm not going to update no system. We can invest in a system, but it's pointless because we're better off just to have nothing. That is such a horrendous answer. Okay, better off to have nothing because you're not going to update the system that you have. I mean, you might as well just put the nails in the coffin yourself from a legal standpoint. Your obligation is to do everything reasonably practicable to protect the health and safety of your workers and to make sure that your worksite is hazard-free to the extent that you can do that. Going into it without a plan is just nonsensical. I mean, that's a non-starter. Now, does your plan have to specifically follow everything that is in the regulation and in the code? No, not necessarily, because they don't apply. But I will tell you this, they're pretty good starting points. And any single OHS policy, plan, procedure, system, program, manual, whatever it is that you choose to call it, at its base level, fundamentally has to start with hazard assessments. Okay, because if you don't know what the risks you are facing are and how to control those risks, you're not going to be able to do a very good job of keeping people safe because you haven't given consideration to what could go wrong, what could impact them, et cetera. So you have to go through that hazard assessment process. Okay. And what I will say is, from my standpoint, there's the ability to go out there and go onto Google or Kijiji and grab a health and safety program off of there. But it's really not worth the paper it's written on in a lot of different ways because it's not tailored to you personally. Okay, now for those of you that are here today, obviously enough, you've got an interest in this, and that's a fantastic, that's fantastic. It's fantastic that you're following up on that, you're pursuing information, et cetera. And I suspect many of you have heard about things such as culture, or you've heard about the internal responsibility system. Now, those two things, you're never going to see that written in the legislation anywhere. When you look through the act, you're not going to see a reference to culture, and you're not going to see a reference to the internal responsibility system. But if you listen to anyone talk about health and safety or read health and safety materials, those two concepts are going to be very front and center. And the reason that they are is because every single time something goes wrong or there's a prosecution, that's what's focused on, a failing of the internal responsibility system or the safety culture just wasn't where it needed to be. Okay. And what we're really getting at, you could spend hours talking about the internal responsibility system and safety culture and how to develop a positive safety culture. And there's flow charts and diagrams and research papers and all of that ties into the internal responsibility system. But what it means to me is exactly what the language in it says, internal responsibility. And what a lot of people fail to realize is that safety isn't about, AgSafe Alberta and the materials that they're giving you. It's not about, well, we hired someone to be in charge of safety. It's not about the paperwork that you have, et cetera. That's all tools. Those are all resources. And for those organizations that have a health and safety department, whether it's farming and ranching or outside of farming and ranching, that's not, those are resources. That's not what health and safety is all about. Health and safety is about what's going on in here and what's going on down here in your heart. It's head and heart, in my mind, internal responsibility. It's how do I envision safety and what is my role in it? Everyone has a role to play. Everyone is responsible for everyone else. And as an individual, where do I fit within that scheme? And so people will typically ask me, well, how do I know if I'm doing everything? How do I know if I've done enough? And my response is, well, listen, if you follow the guidelines that are set out, and the legislation is the guideline, okay? Yes, it's somewhat open-ended because they're general duties, they're general obligations, but that's where you use resources like AgSafe Alberta, like Kaya and her team. That's where you get them involved, and they help distill that down into an understandable and workable fashion. If you take that and say, okay, well, here's the roadmap, here's the plan, I ain't going to follow it, well, you're done. Okay, it's not even, why even go there, right? You've been given the plan, you've been given the resources, but following the plan, following the resources is not in and of itself enough. And the reason it's not enough is because if you're only relying on that, it demonstrates that you don't understand what's at the core of safety, that being your role in it. So I always say, if you follow the plan, you follow the procedures, which is really about following the legislation, and you bring that independent knowledge, you bring that head and that heart to it and assess what's going on in front of you, that's when you're successful. That's when you exercise due diligence. Okay. It's recognizing that, yeah, we have to do these things, not because, well, it's a CYA or cover your butt type thing, but because this is genuinely what we believe is going to improve things here. That's how you improve the safety culture, right? And it's where those pages are missing that you have problems. I tell my clients within 30 minutes of meeting them, and I tell this story seemingly every single time that I speak to a group, but within 30 minutes of meeting clients, I will tell them whether or not we're going to be successful in defending an act or not. Okay. If there was an incident, we've been charged, we're facing an administrative penalty, 30 minutes. And it doesn't turn on how thick the book is. It doesn't turn on how much money you've spent on it, etc. What it turns on is a simple discussion with that particular group, individual, etc. And if their response is, well, we didn't do this because it was too expensive, or I don't know, we followed what our safety people said, and our safety people are always telling us this, and safety, 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 and well, I don't know why the worker did that, the worker should have known better, etc. If that's the response, that tells me that that group or that individual hasn't internalized it. They don't understand their role in it. And so as a result of that, we're going to have an uphill battle. So it's really a matter of understanding your role in it, using the resources that are available and putting it together. If you're going into it without any plan whatsoever, it's just that's nonsensical to me. You wouldn't approach anything in life without some sort of a game plan. And, you know, this is a pretty big thing. There's a lot of marbles that are out there that could essentially go sideways if you don't approach it with that plan.
Zach has asked a question with regards to fine funds. Where do they go? Do they go to help develop safety in that province? What happens to them?
Generally speaking, they'll go into the provincial coffers. Your roads are getting paved. That's part and parcel with where that fine money goes. So I say that, but there's also an opportunity to draft or create what are known as creative sentences. And so that requires a little bit of work from your council. It requires a little bit of work from the Crown. And there's a specific person at OHS that actually deals with those types of things. But that's where you get into, let's say, scholarships that are set up, or donations are made to the burn unit, or specialized training with various organizations and courses being developed, et cetera. So there is an opportunity for it to go to those various outlets or those opportunities. But if it's just a straight up fine and that hasn't been engaged, it's just going into provincial revenues.
And David has added, during Bill 6 and Bill 26, there was an intense discussion about farm and ranch boundary between work and play. Is that clarified a bit more in the context how we think about the Act versus the Code?
I don't think so. Although I'm not sure I necessarily completely understand the distinction that you're drawing between the Act and the Code. But let me tell you this, okay? WCB and OHS, they interact on occasion, but the law has developed a little bit, not differently, but not at the same time in each, okay? WCB, it's very clear what's caught by WCB, right? If you're in the course of arising out of employment, then it's covered, okay? Then WCB falls into place. Keeping in mind that, as I said earlier, WCB doesn't somehow cover you from the OHS liability. But my point is it's deemed to be workplace related for the purposes of WCB if it arises out of or in the course of employment. Well, OHS hasn't gone down that path to the same degree. So that same sort of assessment or that same sort of guidance hasn't really been finalized by an upper level court to say this is how we approach it. But it's a pretty good indication of how it will happen on the OHS side of things. So to bring it back to your question, play versus work. Well, there's a host of WCB cases where individuals are, let's say, going to a company Christmas party and are traveling to go to the Christmas party, or in an accident on the way to the company Christmas party, or are on a retreat and are out using ATVs and four-wheeling and whatever else. Injuries in either one of those instances, notwithstanding that it's not traditional quote unquote work, still covered by WCB, I think the most logical response from an OHS standpoint would be, if there's an expectation that the workers will engage in it, it's work. Okay. And the example that I'll give to you on that on an OHS front, although not specifically related or fleshed out in great detail what the test or the assessment tool is a case out of Calgary called XI Technology. And XI Technology was quite literally a technology company. And during Stampede Week, they decided to have a Stampede party. And they brought in a calf roping machine. And the calf roping machine that they originally saw and were wanting to bring in, for whatever reason, wasn't the one that was delivered. The one that was delivered was this rusty old kind of piece of garbage that wasn't working properly. But nevertheless, the ingenuity of people, never ceases to surprise. And they figured out an end around to make this thing work. But one of the things that was happening with this particular calf roping ride, if you will, is that there was a lever on it that would swing back, and it would swing back with an incredible level of force. And so keep in mind, this was a Stampede party. People could come and go as they please, etc. One of the workers for the technology company was there and was helping out with this piece of equipment, and this lever swung back, hit him in the head, and killed him. And OHS came out and laid charges. And of course, one of the issues in that case was, well, was the worker really at work, or was this, off hours? Was this something else? And that assessment of, well, if it's an expectation that you'll be there for work, or if it's somehow related to work, even in the broadest sense, it's going to be captured by the OHS legislation. So that's the best I can give you in terms of an actual case tying into that. But, I think if thinking through logically, a farming and ranching environment, if you're playing on the bales, we used to make forts on the bales, right? And we used to play on them. I think, that's going to be caught by the OHS legislation, because that's your work site. And you have to be very, very alive to that regardless of what is happening there, if you have tools outside that are left, if you have vehicles, equipment, etc., if it's happening on the work site in particular, odds are pretty good it's going to be work related.
So just a heads up to everyone, we are kind of running down to the last 10 minutes. So if you have questions, please take advantage of this, get them out there. So going back to some of the earlier submitted questions, we have, so many of these have been addressed. So many farms are concerned about losing their farm if something happens. Have you seen it happen to farming or in other businesses?
You're not going to like the answer to that, I suppose, but not in the farming and ranching context, but have seen it happen in other businesses. Now, it's difficult, right? Like the going rate on a fatality here in Alberta, if you're facing charges, is about $350,000. Okay, that's the going penalty, if you will, for a fatality where a company is convicted. $350,000, not a lot of people can afford. Now, here's the thing. There's a bit of a disconnect in the sentencing decisions and in the courts, where there are some decisions that say, the ability of an accused to pay should factor into the decision. And unfortunately, a lot of the Alberta courts have taken the position that, no, if you can't do it safely, you don't do it. So if you can't do, if you're out there performing work and you can't pay the piper, so to speak, when he comes calling, then you just shouldn't be doing it, period. So notwithstanding that there's guidance out there from the courts that a fine should not be so much as to bankrupt a business, a lot of times it actually heads down that path. Now, the courts try to account for that through things like time to pay. Okay, so it's not all doom and gloom by any stretch of the imagination. I have a client that for the last 3 years has been making monthly payments towards that particular fine. So you can work out those types of arrangements with the court, but your books are going to be put under the microscope without a doubt to demonstrate that you don't have the financial abilities to do it. The fine isn't going to be decreased, but it will potentially be dealt with through the time to pay the fine. And so instead of being expected to pay $350,000 within 6 months or instantaneously, you'll be able to sort of go in and say, okay, well, this is what we can do per month. Let's do that for a year or 6 months, and then let's revisit it. And you just keep that process going. Does it happen sometimes, though, where businesses are shut down? Yes, sometimes it does. But I mean, there's obviously enough a host of other factors that combine to make that decision one that makes the most sense economically, practically, et cetera. But it's also a good idea, I mean, keeping in mind corporate vehicles that are available and that sort of thing, to have a discussion with maybe a corporate lawyer or something along those lines to say, how can we structure our assets that we have here such that if something does go sideways, it's not everything that we have that's open to attack, right? And there are legitimate legal avenues that you can set up your affairs in such a fashion, such as only certain or only certain companies are maybe in their asset pools are maybe open for seizure versus, the family trust, let's say.
And what would the repercussions be if a farm has an injured employee and they tell them to lie at the hospital and say it was not a farm accident and it comes out later that it was?
Oh, it's, just don't do it. Just don't do it. Um, I get the temptation sometimes, right? I get the temptation. I actually don't. I'm trying to be relatable here, but just don't do it. It's so problematic when you head down that path. And even if it's not a lie, if it's even the slightest bit of something misleading, OHS is very trigger happy on exercising that whole, hey, you're obstructing an investigation. Okay. I can't tell you how often I have seen that when we're not trying to be obstructionist or my clients aren't trying to be obstructionist, they just maybe don't have the information or any number of things. OHS will follow suit with that. Now, there's not a ton of cases where that has happened, thankfully, because most people are upfront about it, because there is an ability for any statement that you give to OHS, not to the RCMP, okay, but to OHS, that there's a statutory requirement that says they can't use that in the future in proceedings against you. Okay, so you have that statement. They technically can't use it in future proceedings against you. It's a little bit misleading because honestly, if you tell them, yeah, that's where the gun is, okay, we can't use that statement, but let's go get the gun. I mean, they can still use the information. They just can't enter into evidence in the future against you. But if you do that sort of thing and you're misleading, you're dishonest, et cetera, it's guaranteed you're going to be facing obstructionist, any other giving false information is actually a separate charge in the OHS legislation. And I'm familiar with at least one individual that was potentially going to be my client, but wasn't my client for that very reason, having had charges of that nature brought against them. So, I mean, it's not a road you want to head down, my friends. It really, really isn't.
Thank you. So, any kind of last words, anything you want to leave everyone with?
Thanks. I think it's been an interesting few years when you look at the OHS legislation generally. And if you're in the farming and ranching industries, it's been particularly interesting, right? And I've spoken at a number of different venues over the course of the past few years. I've been interviewed by a few different parties, et cetera. And notwithstanding that, there still seems to be, this level of misinformation and misunderstanding out there. Some of the questions that oftentimes get asked demonstrate that the level of education that we really need to have in the farming and ranching industry just isn't there as of yet. And I think a big part of that ties back to how this first rolled out and a lot of the confusion that came about with that. And even now to some of these notions that, well, the legislation is repealed. So, hey, just basic safety standards, which it sounds so simple. And, from my standpoint, I'm really trying to educate people that, listen, it's not as easy as maybe you think it is. It's a lot more complicated. It's a lot more involved. And if you're not sourcing the right information or you're not alive to that, you're going to find yourself on the wrong end of a penalty, an order, a prosecution, something along those lines. It's really just a question of time. I mean, certain people out there seem to think that farms and ranches still aren't touched, right? And I'll be upfront with you. I do some practice out in Saskatchewan. A lot of times, there's a certain degree of discretion that's given with respect to how those operations are approached from OHS and that sort of thing. It's never a hands-off approach for those of you that think that, oh, well, OHS never gets involved. That's not true. Okay. It's just simply not. But I can tell you that in Alberta, there's been a lot more, I would say, aggression, perhaps, on behalf of OHS officers. There's a lot more willingness, let's put it that way, to write orders and to follow up on penalties and prosecutions and that sort of thing. And you're just now starting to see those things work their way through the system. Okay. This legislation took place originally back in 2016-ish, right? And then in 2018, there were some changes, and now we're sort of coming into 2021. Here's the thing. The legislation has been in place for a few years now. This whole introductory period, which didn't really exist, but which a lot of people like to say, well, maybe we're given an opportunity to get up to speed. Okay, that never happened. There was never a moratorium on prosecutions or anything. But to the extent that there was any type of a grace period, it's over. Okay. It doesn't exist out there. And I mean, my practice is indicative of that. Okay. I've got farming and ranching clients. I've got organizations and groups and individuals who are facing these very issues and are trying to stick handle through them, trying to deal with them. And I have to say that in those environments, education was kind of the key piece that was missing. It was just simply not even knowing what it is that they needed to know or what they didn't know. And now they're facing these prosecutions, and I'm having arguments with Crown prosecutors about whether or not the exemption applies or whether it doesn't apply, and whether or not the fine should still be in the nature of $350,000 for a fatality because it's a farming and ranching operation, et cetera. Ignorance of the law is no excuse. That stuff doesn't get you anywhere. So, in terms of a parting insight or parting advice, get yourselves educated, right? Figure out what it is that your operation needs from an occupational health and safety standpoint. Use resources like Kaya, like AgSafe Alberta. Use them to your advantage, right? They're there for you to call on and to tap. And they have invaluable information and experience and can help you wade through these sorts of things. They can help you write your story, right? I mean, think about due diligence as a story. It's the story that you are writing. Today is another chapter in it, right? Coming to this session, sitting here and listening, getting informed about these sorts of things, that's another chapter. Due diligence isn't just one thing, it's the entire story. And it's about writing that story, a good story, every single day, okay? So, hey, it's never too late to start adding a new chapter or to improve upon your story. Start doing that. Leave today's session, follow up with questions. I'm happy to address them to the extent that Kaya wants to forward them to me, but definitely appreciate your time today and your questions, and hope you found it informative. And I do hope that you'll keep in touch. If you do have questions and that sort of thing after the fact, I'm a small town Saskatchewan farm kid. I have a soft spot for my kid, so to speak. I'm happy to have a one-off conversation with you. I'm not going to start the old timer and be like, all right, let's get out the old checkbook here. It doesn't work that way. Okay. But thank you very much. I really appreciate the opportunity and appreciate your time and questions.
Oh, we're so grateful that you did this for us. So we did get a couple of straggling questions on that note. Do you have, I know you're busy, do you have a couple of extra minutes?
I am for sure. I'm capable of staying and ask as long as I need to.
Okay. So the first one is from David. What are your thoughts on the court's inability to waive the victim surcharge when a family member is the victim?
It's a very insightful question, David. I'm going to back that up though one step. My thoughts are essentially, if the family member is a victim, they shouldn't have laid charges. They shouldn't have. I mean, whether it's because the exemption applied or not, even assuming that the exemption didn't apply, in order to lay charges, the Crown has to do two things. One, they have to be convinced that there's a reasonable prospect or a reasonable likelihood of conviction. Okay, so the evidence meets that threshold beyond reasonable doubt. Yep, we think we're going to get conviction when we go to trial. Let's proceed with it. The second thing that they need to do, though, is they need to, regularly assess whether or not the prosecution is in the public interest. Okay, and public interest is this very broad and nebulous concept. A lot of people seem to think they can raise it and say, oh, it's not in the public interest to prosecute me because of whatever. No, it's not. It's not like that. But public interest and public policy, has the family not suffered enough, right? And so I've had cases where mom and pop shop has, maybe a niece, nephew, or one of them has the incident or there's the incident and one of them ends up being fatally injured. We're able to talk to the Crown and say, listen, what are we really trying to achieve here? Because the spouse has already lost everything, right? Like, I mean, their significant other is gone. Now, it's a little bit different when you get into nieces and nephews and that sort of things. There's cases in Alberta, such as Hammett, that talk about how if you're bringing someone into that work environment, you essentially have to take steps to protect them. And niece and nephew is a little bit different than, a spouse or something along those lines. But there's a real question of whether or not the public policy and the public interest issue is satisfied in that regard. In terms of your question specifically, what do I think about not being able to waive it? I'm choosing my words somewhat carefully here. They can waive it on the criminal side of things, eh? I don't know if you're aware of that, but criminal code, they passed some amendments semi-recently, that allows them to waive it in certain circumstances. We don't have that provincially. Maybe it's something that'll happen in the future, but I'm all for consistency. Let's put it that way.
Thank you. And Rachel's question, will our liability insurance cover us for these kind of fines?
No. Very simply, no. The only thing that your insurance may cover you for, and even then it's not very typical or not very likely, is my cost. Okay. So there are certain insurance policies that will say if you were charged with a regulatory offense, i.e. under the OHS legislation, we'll pay for will pay for your defense, will pay for your legal costs. But I got to be honest, those are so few and far between. You'd really have to look and explore that, because it's certainly not a typical type of coverage, and it's only recently that type of coverage has been introduced, to my understanding. So no, and again, that's just legal fees. That's not the actual $350,000 fine or the actual penalty. And again, the reasoning for that being, you can't get insurance for breaking the law. In very simple terms, I mean, that's what it is.
Thank you. Thank you so much for answering those.
No, thank you.
And again, a huge thank you for the explanations and the insight today and all of the information. I think everybody left with a lot, took a lot away from this. And as well, thank you to everyone who was able to join us and the questions that you did ask. They were very appreciated. So this was the first in our webinar series. So I'm just going to share this with you guys before we head off. So we do invite you back on January 26th at 7 p.m. as we discuss getting started on or improving your farm's health and safety program. And again, it's a great opportunity to bring any questions forward with regards to safety plans and get them answered. Join us on February 9th at 12 o'clock in the afternoon for part 2 of our speaker series, where we will be joined by consultant, author, educator, and columnist Alan Quilley as he discusses such safety topics as common sense, and my favorite, we have always done it this way. We have many online events taking place from now through March, and recommend that you do visit the events section of our website regularly to see what's coming up. If you have not done so already, we encourage becoming a member of AgSafe Alberta. By doing so, you will gain access to so many resources and tools that will certainly help you grow safety on your farm. So here's just a quick, again, view of what we do, what we services we offer. If you have questions, reach out, do ask. And again, just a final thank you to Chris. This has been informative and enjoyable.
Thank you so much. I appreciate the opportunity. It's my pleasure. And thank you so much for hosting.
Thank you.